Okay. So welcome to our second week of our end of life planning series. And tonight we're going to be talking with two esteemed guests, two wonderful lawyers, Tom and Jean. And I'll just ask them to introduce themselves briefly. Tom, would you like to go first?
Sure. I'm Tom Tarbox. I'm an attorney, of course. I finished law school in 1979, so I've been doing this for quite a while. Most of my practice does fall under the umbrella of what we call probate. But within that, we talk about writing wills, powers of attorney, wills and trusts. And then there's a big area of my practice that involves guardianships and conservatorships. Those are commonly set up when people lose the capacity to make their own decisions and someone needs to be appointed to make decisions for them. A lot of those people are elderly, but from time to time, it does involve somebody who has a developmental disability and things like that. There's a lot of work that goes into the area that we call Medicaid planning or other phrases like that. But I am here to talk this afternoon or this evening about basics of writing a will and how to begin estate planning.
Thank you, Tom. And Jean, could you briefly introduce yourself?
Sure, I'm Jean Davis. I've been practicing law in Iowa for over 30 years. And I also was adding an aside, and that is that Tom has been too humble in his introduction. He's a recognized expert in this area. He's recognized throughout the state. So we are very blessed to have a session with him tonight. And Tom, I feel like when I'm listening to you, I should apply for continuing education credit. I started out doing my legal practice, legal career as a legal aid lawyer. And I was a legal aid lawyer for several years. And I had a number of clients that had issues that fell within this area of the law and guardianships and conservatorships, as Tom described. And then as I continued in my legal career, I took a position in the Attorney General's office, was a prosecutor in the Attorney General's office for several years. And then I retired from state government a few years ago as the Iowa's chief administrative law judge. So I've had a mix of experience, but I've had substantive experience with basically everything that we're going to talk about tonight.
Thank you, Jean. And we'll get started with Tom sharing just a little bit about wills.
Sure. So as I said, a large part of my practice does involve helping people with their estate plan. And the most fundamental document in that area is a will. So to talk a little bit about what a will is. A will basically is a written document that describes where you want your property to go upon your death. But one of the most important things to understand is that the will only operates on those things that are in your name alone. So let me distinguish a couple of thoughts about property law. There are a number of ways of holding title to property that your will just simply will not act upon. So for example, my wife and I own our condo as joint tenants with rights of survivorship. So that's a very important legal phrase, joint tenant with rights of survivorship. What that means basically is that we own it together. If one of us dies, there's an affidavit that has to be filed, but you don't need to go through probate. And my will doesn't really act upon our condo because of the way we hold title to that. So think very closely about this concept of title. So if one of us dies, then the other owns the condo in our individual name. Well, then when I die, if I'm the second to die, I mean, obviously there's no one around to sign a deed. So how do we transfer title to this condo, either to our son, who's our beneficiary, or if it just simply needs to be sold and converted to cash? Well, obviously I'm not around to sign that deed. So somebody has to go to court, become appointed to be the executor if there is a will, the administrator if there is not a will, and then get the court's authority to actually sell the property. So that's one aspect. There are other ways of holding ownership to property. Another classic example that a lot of people have is life insurance. Well, life insurance is a contract that I have with the insurance company that when I die, they will pay a certain amount of money to who I tell them to pay it to. So that's called a beneficiary designation. My will does not operate on beneficiary designations. That happens outside of court, outside of my will. Okay. Retirement funds are similarly titled as beneficiary accounts. I have set money aside for my retirement, and if there's still money there when I die, I have designated a beneficiary. Again, my will doesn't operate on that. So it may beg the question, how important is a will? Well, I think it's fundamentally important because number one, we don't know who's going to die first or second in a married couple or a couple. Number two, it may be that death ensues when a child is not old enough to take care of his or her own property. And what are we going to do about all these mixes of things? So a will lays out where you want your property to go, who you want to manage that property for you when you're gone. So within a will, I want to talk about three types of bequest, maybe four. Iowa has passed a law, I think all states have it probably now, that allows you to incorporate into your will a list of your tangible personal property, and then you can say, who gets that tangible personal property? So if there are family heirlooms, antiques, jewelry, things like that, so it has to be tangible, it has to be personal property, of course. So tangible is that property you can touch. A bank account is not tangible because you can't go touch the money that's in your bank account. But jewelry is, furniture is, the paintings on the wall are, and you can keep this list. And then if by chance you change something, you change your mind about who should get what, maybe you've already given the jewelry to this daughter or that daughter, or maybe you've already disposed of your household contents as you go as you downsize or something. The beauty of that list is you can change it whenever you want, and you don't have to go through all the formalities of signing a will. You don't have to have two witnesses. You don't have to have this signing ceremony, but you must both date and sign the list every time you change it. That way we know which list to follow when the person dies. So that's one type of property I wanted to talk about. But another type of property within a will is something that we do call a specific bequest. If I say I leave my Picasso painting to my son, and I've only got one Picasso painting in the house, and of course I don't, we know what I'm talking about. We're very specific, okay? The next kind of bequest is a general bequest. If I say I give $10,000 to my brother, we don't know if it's in this account or that account or under the mattress. It's just $10,000. It's general in nature. And then the final type of bequest is what we call the residue. So now that I've given away specific pieces of property, and now that I've made general bequests to this person or that person, what do I do with the rest of it? That's called the rest, residue, and remainder. Okay. So in so many of the wills that I write, it's for a married couple who has children. So the classic example of a will is everything to the surviving spouse and then to the children in equal shares. Classic will. There are many variations on that. When you get into a blended family, you've got children from the first marriages. Maybe you want certain family property to stay within one group of people. Maybe you have minor children, and if both parents die, who's going to become the guardian of that minor child? Another question is, who's actually going to handle all these things? So we talk about an executor. And people frequently ask me, well, who should I name as an executor? My thought is you want somebody who will, A, follow your wishes, B, be somewhat sophisticated and know what they are responsible to do, and to work closely with the attorney who's working with them And so that's an important factor. I mentioned a couple of times now to nominate a guardian for the minor children. The court will listen to a nomination. The nomination in the will is not dispositive because, maybe that person's no longer around, maybe that person's not fit, maybe, but at least the court will listen to that nomination. Don't want to get too far afield, but parents are the natural guardians of their children. So of course, I've written wills for couples that have been through divorces and have minor children. And if my client dies first, those children naturally go with their biological parent or with their legal parent. They are the natural guardians. But if both parents die when the children are minors, the will is an opportunity to nominate who it is that you want to be the guardian of your children. So for me, that's a very important factor. Another issue that comes up, again, speaking about minor children, what if they're not sophisticated enough to handle the assets that come to them? In a lot of situations, we have what we call a testamentary trust. So a testamentary trust is a trust that you set up within your will. So that trust doesn't even exist until you die, the will is administered, and then the trust is created to hold the assets maybe for that minor child until the minor child is old enough to handle their own. One of the great advantages of using a will to set up a testamentary trust, as opposed to using a conservatorship, if a child's under a conservatorship, they reach the age of 18, they're entitled to get their property and handle it themselves. Whereas if you create a trust under your will, you can delay the receipt of that money until they're 25 or 30 or 50 or whatever it is you want to do because you're in charge. And I frequently have discussions with my clients about, what you or I might have done with money when we were 18 versus what we would do with it when we're 25 and what we would do with it when we're 30. So a lot of these kinds of wills that I write, it's half at 25, half at 30. By 25, hopefully they've gone through college. If they've got student loans to pay off, that's fine. They can use the money for that. Or by the time they're 30, maybe they're married, starting a family, need to buy a house, and they come into some money. So you just sort of know your own children and you know the decisions that you want to make and so forth. A question that people frequently ask me is, okay, we're coming in to see you about writing a will. What do you want me to bring with you, with me to see you? And that's sort of hard. I mean, I don't want to meddle too much in someone's financial affairs, but there are certain things that I do need to know. Give me a general idea of what your property is. Do you own real estate? And if so, what is it? Where is it? What's its value? And so forth. I'm particularly interested if people have property outside the state of Iowa. Okay. Another thing I want to know is a general idea of the size of their estate. I want to know if there's tangible personal property that's of particular interest to the family. A lot of people just come to me and say, no, we don't have anything. Some people do have. Recently I had a family where the wife had inherited a farm from her parents. So that was sort of special to her. That was inherited property that she wanted to treat somewhat differently from all the rest of the property in their estate. So there's many, many opportunities to do many interesting things within a will that you might not be able to do without writing a will. What else do I want people to bring with them? I want to know if they have life insurance. I want to know if they have retirement funds. I want to know how they hold their bank accounts. Because going back to the very beginning of what we were talking about, I want to make sure that the plan I put together under the will agrees with the things that they have done outside the will. So I mentioned that you can hold an account in joint tenancy, and that doesn't have to be with a spouse. That could be with a sibling. That could be with a child, with a niece or nephew, or whoever it might be. If you have made that decision, is there something we need to balance within the will? And there's a lot of coordination of assets that I think is very important and that you have to think about. Another thing that we talk about in preparing an estate plan is at least to have some little conversation about taxes. That's another reason people come to an attorney and they're very concerned about what will the tax implications of this be. So I talk to people about there being two kinds of taxes. There's income taxes and there's wealth transfer taxes. There are two levels of taxes. We have federal taxes and we have state taxes. So let's talk first about income taxes, because that really doesn't change a lot. I mean, just like we all file our income taxes every year, you've got income, you've got deductions, you pay your tax on the balance. But when we're dealing with an estate, we've got a couple of very interesting issues that come up. A person who dies, technically, their tax year starts January 1, just like everybody else's, but it ends on date of death because they're not around to earn income anymore. Their estate should get an ID number and be the taxpayer going forward. If you've got a married couple, the married couple files their joint tax return at the end of the year. It's not a big deal. But when you have a single individual, there really is a short tax year there. A lot of times you don't even get the tax information till the end of the year. So that's a little issue to deal with. And then every estate that's open through the court system becomes a taxpayer. It gets an ID number and it has to file a tax return just to close out that ID number. Even if there's no taxes to pay, it's an issue that needs to be addressed. And then on the wealth transfer side of this discussion, we have the federal estate tax, but frankly, the federal estate tax is almost non-existent. Every individual today has an $11.7 million exemption from federal estate taxes. In a married couple, it's twice that number. So who really has to pay federal estate tax except really, really highly compensated people? Movie stars or rock musicians or whoever. And if you've got that kind of tax problem, there are some really, really interesting, sophisticated planning tools that you can use to minimize that. And one of the greatest is charitable intent. In Iowa, the wealth transfer tax is called the Iowa inheritance tax. And many, many states have abolished their inheritance tax. Iowa has abolished about half of it. Iowa has said, we will not levy an inheritance tax on children or grandchildren or parents or grandparents, but we will levy a tax on brothers and sisters or nieces and nephews or aunts and uncles or friends and neighbors. So another aspect of planning is to consider these tax issues. And that sometimes comes as quite a shock to people that, oh, if I leave something to my brother, he's going to have to pay a tax. And that's just simply the way it is in Iowa. So yes. So what I traditionally do is have a meeting with a client. And a lot of times these days it's over Zoom. We're getting pretty good at this. And it's really, really important to talk to a client about what is it that you want to accomplish. I mean, I've got all my ideas about what a traditional will is, and I can talk about how these things fall into play, but some people are concerned about taxes. Some people are concerned about, what do I do about a disabled child? Some people are concerned about preserving a legacy asset. And that's a very important thing for we attorneys to listen to make sure that we are connecting with our clients and doing what they want us to do. And as I mentioned, there are many, many tools that you can use to plan through all these individual problems. So we have talked about, let me talk too about how often do you have to look at your will, revise it, change it, whatever. And what I traditionally tell people is this will is good for as long as your life stays relatively stable. But major changes in your life should cause you to re-examine your will. Major changes might be the loss of a parent and maybe some inheritance. Might be a marriage or a divorce. Might be children or a child, having special needs. So, the will that I wrote as a young attorney before having a child was different from the will that I wrote when I had a young child who, if we both died in a plane crash, couldn't handle his own money, versus where he is today, working on his PhD in Paris. I mean, there are just so many things to think about. And it's a real give and take in the conversations I have with clients. I mean, a lot of clients come in with maybe some basic notion of what a will is. And then I start talking about some of the nuances, and they're frankly sometimes amazed. Some of them feel it's just way too complicated. But there's a certain amount of that complication that's necessary in order to get to the result where you want to be. So I just heard my clock chime. It's worth a half hour. So I'll stop here and let Jean talk for a bit, and then we can have some questions. All right?
Thank you, Tom.
Sure.
Thanks, Tom. I'm going to be talking about advanced directives. And I think an easy way to think about advanced directives is simply to think of them as written directions for future medical care. And in Iowa, we have two authorized types of documents that we can fill out to take care of that planning and those directives for our future care. The first one is called a living will, and that may sound a little bit like an oxymoron, given that Tom just told us that wills are effective at your death. A living will is actually a document that addresses what you would prefer to have happen for life-sustaining procedures if you were in a terminal illness situation and you could not make decisions for yourself. An Iowa statute for authorizing a living will is Iowa Code Chapter 144A. And on the handout that I passed out, I have a simple reference to it, and it's called the Life Sustaining Procedures Act. That was passed in 1985. And the policy statement that the legislature placed in front of the statute, I think, is an interesting one. So I'm just going to read a couple sections. It says the legislature expressly noted that all adults have the fundamental right to control the decisions relating to their own medical care. The legislature further provided that the artificial prolongation of life for persons with a terminal condition may secure only a precarious and burdensome existence while providing nothing medically necessary or beneficial. In order that rights and intentions of persons with such conditions may be respected, the legislature enacted Iowa Code Chapter 144A to recognize the right of an adult to make written declarations regarding the withholding or the withdrawing of life-sustaining procedures. There are some elements that are key elements to any type of written declaration. And the first is that it must be in writing. One of the links on the handout that I sent to you also has a link to a form that has been made available by the Iowa State Bar Association, which is a living will form that conforms to the statute. So that is available for your use if you wish. To make a living will, you must be 18 years or older. And a living will is only effective at the time that the declarant, that is myself, is terminal and I can no longer make decisions for myself. It must be signed in the presence of two witnesses or notarized. The witnesses cannot be your healthcare provider. And the statute sets out a specific declaration that covers what I have just described. And that is the declaration that is put in the form. The The document, when it's completed, should be given to your doctor, your healthcare provider. You should give it to family members or other agents. And I'm going to get to that term in a minute when we talk about the next type of document. A living will is revocable. You can change it at any time. And one of the key questions in a living will is who gets to decide if your condition is terminal. The statute says, the law says that that is determined by your attending physician, and it must also be confirmed by another physician. And the other question is, what is a life-sustaining procedure? In Iowa, that definition contains two elements: use of a mechanical or artificial means to sustain, restore, or replace spontaneous vital function, and which, when applied to a patient in a terminal condition, would only serve to prolong the process of dying. So those core elements of a living will are a written declaration by somebody 18 years or older that has been witnessed, that contains the necessary declaration that would be triggered at the time of terminal illness or I can't make my own decisions. And I'm going to flip now into the other type of document because before I do that, I want to just talk about things that are commonly, people have questions about what is a life-sustaining procedure. And not included in the definition would be basic hydration and nutrition, unless those are delivered by some sort of mechanical or artificial means. So what we're talking about here would be things like tube feeding, assisted breathing, resuscitation, ventilators, those types of things. Anything that's necessary to provide for comfort or alleviate pain is not a life-sustaining procedure and would be applied regardless. So the second type of document is called a durable power of attorney for healthcare decision-making. And in that, you're making, again, a written declaration that if you are not able to make healthcare decisions for yourself, you are choosing a specific person to make those decisions for you. Unlike the living will, however, the durable power of attorney for healthcare decision-making is broad and can be triggered even if you do not have a terminal illness. So let's say that I have been in a car accident. I may be temporarily unable to make healthcare decisions for myself. My agent that I designate under my durable power of attorney for healthcare decision-making can step in to make those types of decisions. And more importantly, that document that I complete can be good or effective throughout my lifetime. So I may have this car accident. I need somebody to help make decisions for me. I fully recover from it. I resume my own decision-making. But then 10 years from now, I may have another medical condition that would require somebody to step in and make decisions for me. So the durable power of attorney for healthcare decision-making is a much broader, more applicable, I think, commonly document for people than the living will. What can also be important about the durable power of attorney for healthcare decision-making is it can be triggered without some of the cumbersomeness of the living will. You don't have to have a physician make a determination that there's been a terminal illness, because terminal illness is not a requirement to trigger the agent to make decisions for you. And it doesn't have to just be a life-sustaining procedure. It could be a consent to a necessary surgery that's not necessarily just life-sustaining. So important distinctions between the two types of documents is the living will is more narrow and it's triggered at end of life, terminal illness stage, and it pertains to life-sustaining procedures. The durable power of attorney for healthcare decision-making is broader, used most commonly when circumstances for any type of surgery, procedure, test, something diagnostic would be required when I can't make decisions for myself. But you start from the premise, one, every adult has the right to make those decisions themselves. And two, these documents set up a plan that somebody can follow in the event that you can't make those decisions for yourself. Again, this document must also be in writing. It must also be witnessed or signed in the presence of a notary. Your witness cannot be your medical provider, and one of the witnesses cannot be related to you. It also should name an alternative agent. So if I have a son and daughter and I name just my son, I might name my daughter as the alternate so that if he would not be able to serve, she could. So it's important to set up an alternate too. I think the PDF document that I sent out to folks too has a link for the Iowa State Bar Association form for the durable power of attorney for healthcare decision-making. And there's also a third form, and that is a combined form to do both a living will and a durable power of attorney for healthcare decision-making. I can speak also from personal experience in dealing with my mother's last illness. It was extraordinarily helpful that I had many opportunities to discuss with her wishes, but also I had very clear written instructions about what she wanted. She did a very lengthy durable power attorney for healthcare decision-making. And I have to say, as painful as it was at times to make some of those decisions, she gave me a gift by giving me her preferences and instructing me in what she wanted to have. Okay, I think I lost, I might have lost connection for a minute, so I'm going to go back to, and bear with me if I repeat. I was saying from personal experience how important it can be for surviving family members to have this type of written guidance so that they know exactly what it is that you want to have happen. And I consider, in dealing with my mother's final illness, it to have been one of the best gifts that she could have given me, to give me a clear path and an understanding of what it is that she wanted. By way of practical tips, I would say not just filing it with your primary physician. I would, if you are accustomed to going to a particular hospital, I would make sure these documents are in your chart. I would make sure that you give multiple copies to not only your agent and the alternative, but also to any other siblings that you do not name or relatives that you do not name, but you think maybe part of the mix in some of the decision making. So if you anticipate that there's going to be disputes in the family or disputes amongst the siblings or your children about these types of decision making, giving these copies of these documents can be very, very important so that people know precisely what your wishes are. And then having those candid conversations with your family members and the people that you want to have make decisions for you. The other thing that I found helpful when I was kind of placed into a crisis situation with my mother, she had an immediate emergency surgery at the small local hospital where she lived, but then she had to be transported to a major medical center. And I was going to be following her, but she had given me a file of these documents that I had with me that I could then take to that medical center, because that medical center didn't have any of her records. And from the outset, there became some need to make decisions. And so they needed to know who was going to make the decisions. And I wanted to make the decisions that were consistent with what she wanted. So having that ready folder of documents to take with me was extraordinarily helpful. The other thing that the durable power of attorney for healthcare decision-making can assist with is getting access to records. So when I wanted to kind of educate myself about what I needed to even ask the doctors, I could have access to the records to kind of educate myself. So that is helpful with a durable power of attorney for healthcare decision-making. And the other piece is that living will chapter that I talked about earlier, 144A. 144A specifically references 144B, the durable power of attorney for healthcare decision-making statute. So the agent who may have to step in is automatically recognized under the durable power of attorney for healthcare decision-making document. You don't necessarily have to have a physician make that determination of terminal illness, because there's a ready agent there to make decisions if decisions cannot be made by you. I guess the last tip that I would have just from experience is, if you are the person that has to act as the agent for someone that you love, care about, be prepared to be an advocate at times. You sometimes have to ask a lot of questions, ask hard questions, but be prepared to be an advocate at times. With that, I will stop so that we can have time for questions and answers.
Thank you, Jean. I was wondering if we had any questions, and I just want to let people who are watching this know that if you're looking for this document that Jean is referencing, it's at cathedralchurchofstpaul.org, and it's under our small groups section. And I see a question.
I'm John Bowler. I'm Nicola's husband, as you probably know. I have a general question, and that is that a husband and wife will no doubt make separate wills, and then one of the partners, in general terms, I don't want to be personal about it, but in general terms, one of the partners dies first. And then I wondered if there are circumstances, there clearly are, where the surviving partner wants to change something about the original will. So is that a possibility, or does it have to be built into the original will?
No, it very much is a possibility. It's very rare to have what we call contractual wills. A contractual will basically is where the two of you make a contract with each other that this is the way we will dispose of our estate, and we won't make any changes after one of us goes.
Yeah.
But life is very variable. There could be a second marriage, depending upon the age of the couple. I mean, it's one thing, a mature couple, but a young couple who suffers a loss, and the surviving spouse remarries, has children from a second marriage. I mean, you just simply can't be tied down too tightly. However, you might face a situation maybe in a second marriage where there are children from the first marriage, and there are certain legacy assets that you do want to make sure are somewhat locked down. That creates a sort of an interesting challenge for the person writing the will to get that expressed properly, to reflect the goals of the client who came to me. It is possible. I don't think I've ever, frankly, faced it, but I do remember going to a continuing legal education seminar where this was presented as a very real problem. Does the attorney have a conflict writing a will for both the husband and the wife? As long as it's a happy marriage, I suppose not, but suppose I sit there with two clients, and the next day, one of the clients calls me and says, "Now, don't tell my wife, but I actually have a child over here. You cannot be in that position." So it was an interesting, thought process, ethical dilemma, but it doesn't really present itself very often. So by and large, I think contractual wills are a terrible idea because it does lock you down and there's no flexibility. Theoretically, it's possible, and there might be the appropriate case where it's reasonable and proper.
Yeah, what I'm kind of thinking of is that there's a partial flexibility. There are certain aspects of the will which are inflexible,
Mhm.
and the majority is flexible. So my personal circumstances, I was married before, and my wife was as well. She has no children from the former marriage, but I have two daughters from the former marriage.
Right.
One of which, is struggling under the present circumstances in England.
Hmm.
And so my particular case would be to try and offer some provision, especially for her, for the future.
Sure.
And she will inherit from my former wife. And I left my former wife the house without asking for a share in that house. So, and that's a house in Surrey in England, and that's a pretty expensive house. So
Okay.
my children from the former marriage will, inherit the benefit of that, which was pretty significant. But I didn't need it really. And so I moved on. So that's the situation I would be in. So I want to make some provision for one of the daughters at least, because the other one is more mature and thriving in a different way.
Sure. And that's a classic issue that presents. I mean, parents know their children, know which children will handle money more responsibly than others.
Yeah.
I've written them in such a way that one child gets the benefit immediately, the other child gets the benefit spread over 5 years or 10 years or whatever. Or maybe it's just simply held in trust because the child is a spendthrift, or the child has substance abuse problems, or the child's in an abusive relationship and you just don't want to provide all that money at once to a bad situation. So, as I said, there's lots of different family scenarios that present themselves when I talk to people about writing wills. And yours is a classic example.
Yeah, thanks.
If I may have a follow-up question there, Tom. So some of our assets, as you mentioned, you particularly want to know if people have assets overseas or outside of state and so on. And what can you tell us about that?
That is very interesting because all of a sudden I have had a handful of cases where my client does have property overseas, and it continues to be a struggle for me. What I'm more comfortable with talking about, and it'll sort of connect here. In the United States, an American citizen who has property in another state, real estate is governed by the law of the state where the real estate lies. Personal property is governed by the law of the state where the person resides when they die. So I have had cases where I had to do probate in Iowa, and then we call it ancillary probate in Florida, in Michigan, in Missouri, in Illinois, and we end up doing probate twice. We have to find an attorney in the other state, and I don't know attorneys in other states. So when it comes to international estate planning, we've got a totally different situation, but somewhat related. Europe has different rules about inheritance. In the United States, you can disinherit a child. And I understand that there are certain European countries where you cannot do that. It's called forced heirship. You cannot write a child out of a will. I don't know if that applies in England or not. I have a client who happened to have property in France and also has a child who lives in France. Very interesting issue. We wrote a will for the United States assets, and he had an attorney in Paris who wrote a will for his European assets. It still is a bit of a mystery to me. I had an estate where the beneficiary, the child, lived in Moscow. We sent a fair amount of money to Moscow. And there was far below the federal estate tax limit. We didn't have to worry about federal estate taxes. He was a child. We didn't have to worry about Iowa inheritance taxes. But the mother had immigrated to the United States. The son, as an adult, lived back in Moscow. But when the mother died, he was an only child, and all this money went to Moscow. It was a fascinating issue. But I really am personally still a little bit perplexed about how to plan for an international estate. And the only experience I've had, we sort of settled on a US will and a French will. I don't know if that's 100%. And I have looked online, I have looked for an opportunity to go to a continuing education seminar on international estate planning. I have a friend who immigrated from the former Yugoslavia. He and his brother own an apartment in Belgrade. All of a sudden it has come up 3 or 4 times that I have clients who have assets in other countries. Good friends from Mexico. Her mother died in Mexico. There's a property down in Mexico of which she owns a 1/5 share. That's really fascinating.
Wow, thanks.
Sure.
Thank you.
Jean, I guess I have a question for you because it comes up with me frequently. And that is when a couple, a family, individual has multiple children, and the parent wants to make all the children the executor, or all the children the agent under a power of attorney for healthcare. How do you deal with that situation? Because the children may not agree with each other.
When I had that situation previously, I advised that they couldn't name them all equally. It wasn't going to be like a vote by committee. You had to pick somebody that you thought was going to square best with what you wanted. And I had another life experience with that. My mother-in-law picked me as her agent, even though her spouse was living, because she knew her spouse was not going to follow her wishes.
Yeah.
So I say, basically, the way I advised clients is that it couldn't be a vote by committee. You needed to pick somebody, but make sure that person has got a clear understanding of what it is you want, because the last thing you want in a family relationship is to have disputes about that at the time that decisions need to be made. And even though there's a procedure within the living will statute for, contesting and, otherwise raising questions with regard to these decisions and court involvement, that is the last thing that you want to have happen. And it's the last thing that you want to have happen within those familial relationships. It's extraordinarily stressful to have to make these decisions. And when it came to the decision making for my mother, I have a surviving sister. She was not named as the agent. She was named as the alternate. And so what I did basically was discuss every step of the way with her. She was present with me a lot of the times. We were in close proximity to where my mother was living at the time, which helped. But I think having that extra set of eyes and ears when you're talking to the doctor, trying to be on the same page if you can, I think is invaluable, because that's another source of support for you as you're going through that process of making the decisions.
I agree with that, but frequently clients just can't pick between children. Oh, this child will be upset if I don't also name them. And I do try to convince them that for the sake of making a decision, somebody needs to be in control. And so I'll put in provisions. I'm going to name this child, hoping that he or she will confer with their siblings, but ultimately we have to know who's going to make the decision, number one. And number two, what you just said too, is a great way of resolving issues. Make that second child the alternate so that they're still involved. So yeah, I think that's good. I also have a set of matrices that I picked up at a seminar one time And it's sort of like the instructions your mother left you. If this is my condition, do I want pain medication? Do I want chemotherapy? Do I want blood transfusions? Do I want major surgery and so forth? And the scenarios are things like, I'm in a car accident and the doctor believes I'll probably come back to full faculties. Now what do I want? Or I have a terminal illness, cancer or whatever, from which I will die in a relatively short time. It's not necessarily end of life, but maybe I'm in a coma or medically induced coma from a car accident or something like that. What if it's Alzheimer's? I've lost my essential faculties. I'm never coming back. And I've made some interesting observations, at least I think they're interesting. Number one is that women are tougher than men because all men will check, I want pain medication. And when my father died of cancer, of course, he needed pain medication. And when my mother died, she wanted all of her kids to be around her and to be able to continue to converse with them and to share with them. Of course, you know, my mother was a nurse and she knew everything that was going on. And I've always thought about that. And I think about it a lot being in this area of the law. What must it feel like to know that you are coming upon the end of your life and the decisions that you have to make? And who are you going to trust to help you make those decisions? I mean, these are, you know, weighty decisions. I find that clients most often appreciate a human approach to these issues. Some people have said to me, how can you talk about that stuff? I mean, they're so afraid of dying. They're so afraid of illness. And, you know, truthfully, I am too, but I have just dealt with so many people in this area of the law, and I have seen the comfort they derive from a good conversation. And it's probably what keeps me going, to know that you're doing something that maybe is helping them. It's not any great knowledge I have, but I do have some. And to share that with somebody, to get their feedback, it's a more interesting thing than, I don't know, a lot of things other lawyers do, securities and corporate mergers and acquisitions. I mean, yeah, give me a good human problem. I'm much happier. Yeah.
I have a quick question. I think it's for Jean. Jean, so Thomas talked about minimum ages and how age can relate to beneficiaries and so on, and how that might change what you do. Is there a minimum age for someone who can be named in a durable power of attorney?
I didn't hear the question.
Yeah, I wondered if there's a minimum age for someone who can be named to make the decisions under a durable power of attorney.
Basically the age of majority, so 18. You can name somebody 18.
Okay, thank you.
Is there any last questions? Okay. Well, thank you so much for coming tonight. It's been a wonderful conversation. And I so appreciate the expertise of Tom Tarbox and Jean Davis. It's wonderful to have you here with us tonight.